anti-money laundering laws and their enforcement. Before we go into this video, we urge you to like and share this video and subscribe to our channel, India Business Insights, for more such videos. Also, please make sure to press the notification bell. Now, we come to what really money laundering is. Money laundering is concealing or disguising the identity of illegally obtained proceeds so that they appear to have originated from legitimate sources. It is frequently a component of other, much more serious crimes such as drug trafficking, robbery, or extortion. According to the IMF, global money laundering is estimated between 2 to 5% of the world's GDP. There is a global consensus on placing responsibilities on countries to curb money laundering. Several countries have been sanctioned for their failure to do so by organizations such as FATF. How does money laundering happen? It involves 3 steps: placement, layering, and integration. Placement puts the dirty money into the legitimate financial system. Layering conceals the source of the money through a series of transactions and bookkeeping tricks. In the case of integration, the now laundered money is withdrawn from the legitimate account to be used for criminal activities. Money laundering can take several forms. Some of them are structuring, also called smurfing, bulk cash smuggling, cash-intensive businesses, trade-based laundering, shell companies, round-tripping, gambling, black salaries, tax amnesties, transaction laundering. Now we come to the impacts of money laundering. Economic impacts: undermines the legitimacy of the private sector, undermines the integrity of financial markets, loss of control of economic policy, economic distortion and instability, loss of revenue, security threats to privatization efforts, volatility in exchange rates and interest rates due to unanticipated transfer of funds, rise of economic prices, and lastly, it affects trades and international capital flows. Now, coming to the social impacts: increased criminality, decreases human development, misallocation of resources, affects trust of local citizens in their domestic financial institutions, and lastly, it declines the moral and social position of the society by exposing it to activities such as drug trafficking, smuggling, corruption, and other criminal activities. Next, we come to political impacts. Firstly, it initiates political distrust and instability, and it also leads to criminalization of politics. Next is the steps taken by the Government of India to prevent money laundering. First is the Criminal Law Amendment Ordinance of 1944. It covers proceeds of only certain crimes such as corruption, breach of trust, and cheating, and not all the crimes under the Indian Penal Code. Next is the Smugglers and Foreign Exchange Manipulators Forfeiture of Property Act 1976. It covers the penalty of illegally acquired properties of smugglers and foreign exchange manipulators and for matters connected therewith and incidental thereto. Next is Narcotic Drugs and Psychotropic Substances Act 1985. It provides for the penalty of property derived from or used in illegal traffic in narcotic drugs. Next, Prevention of Money Laundering Act 2002, PMLA. It forms the core of the legal framework put in place by India to combat money laundering. The provisions of this act are applicable to all financial institutions, banks, including RBI, mutual funds, insurance companies, and their financial intermediaries. PMLA Amendment Act 2012. It adds the concept of reporting entity, which would include a banking company, financial institution, intermediary, etc. PMLA 2002 levied a fine of up to Rs 5 lakh, but the Amendment Act has removed this upper limit. It has provided for provisional attachment and confiscation of property of any person involved in such activities. There are also multiple agencies involved in the enforcement of these laws and in the investigation of a breach of these laws. First is Financial Intelligence Unit, IND. It is an independent body reporting directly to the Economic Intelligence Council, EIC, headed by the Finance Minister. Next is Enforcement Directorate, ED. It is a law enforcement agency and economic intelligence agency responsible for enforcing economic laws and fighting economic crime in India. One of the main functions of ED is to investigate offences of money laundering under the provisions of the Prevention of Money Laundering Act 2002, that is the PMLA. It can take actions like confiscation of property if the same is determined to be proceeds of a crime derived from a scheduled offence under PMLA and to prosecute the persons involved in the offence of money laundering. India is a full-fledged member of the FATF and follows its guidelines for the same. The anti-money laundering efforts also involve placing significant responsibility on the banking system to help in identifying money laundering activities and also placing responsibility on commercial entities and professionals such as CAs in identifying money laundering risks. Now, we will talk about the global efforts to combat money laundering. First is the Vienna Convention. It creates an obligation for signatory states to criminalize the laundering of money from drug trafficking. Next, the 1990 Council of Europe Convention. It establishes a common criminal policy on money laundering. G10's Basel Committee Statement of Principles. It issued a statement of principles with which the international banks of member states are expected to comply. Next, the International Organization of Securities Commissions, IOSCO. It encourages its members to take necessary steps to combat money laundering in securities and future markets. Next, the Financial Action Task Force. It has been set up by the government of the G7 countries at their 1989 Economic Summit, has representatives from the 24 OECD countries, Hong Kong, Singapore, the Gulf Cooperation Council, the European Commission. It monitors members' progress in applying measures to counter money laundering. The famous 40 recommendations are given by FATF. Next is the IMF. It has pressed its 189 members countries to comply with the international standards to thwart terrorist financing. And lastly, we have the United Nations Office on Drugs and Crime. It proactively tries to identify and stop money laundering. Now, we move on to understanding the legal standing of PMLA. Money laundering refers to the conversion or misrepresentation of money which has been illegally obtained by unlawful sources and methods. It is a criminal offence in India and charges in this instance refer to statutory provisions of the Prevention of Money Laundering Act 2002. The PMLA was enacted in response to India's global commitment, Vienna Convention, to combat the menace of money laundering. These include: first, United Nations Convention against illicit traffic in narcotic drugs and psychotropic substances, 1988, the Basel Statement of Principles, 1989, 40 Recommendations of the Financial Action Task Force on Money Laundering, 1990, and Political Declaration and Global Programme of Action adopted by the United Nations General Assembly in 1990. The PMLA is applicable to all persons, which include individuals, companies, firms, partnership firms, association of persons or incorporations, and any agency, office or branch owned and controlled by any of the above mentioned persons. So what are the recent amendments in PMLA? Clarification about the position of proceeds of crime. Proceeds of the crime not only includes the property derived from scheduled offence, but would also include any other property derived or obtained indulging into any criminal activity relatable or similar to the scheduled offence. Money laundering redefined. Money laundering was not an independent crime, rather dependent on another crime known as the predicate offence or scheduled offence. The amendment seeks to treat money laundering as a standalone crime. Under Section 3 of PMLA, the person shall be accused of money laundering if, in any manner, that person is directly or indirectly involved in the proceeds of the crime. Concealment, possession, acquisition, use, or projecting as untainted property, claiming as untainted property. And lastly, continuing nature of the offence. This amendment further mentioned that the person will be considered to be involved in the offence of money laundering till the time that person is getting the fruits of activities related to the money laundering, as this offence is of a continuing nature. What are concerns raised about the amendments in PMLA? First is the possible misuse of powers. There is a strong possibility that PMLA can be invoked against a political rival or a dissenter because the process in itself is a punishment. Next, issues with ECIR or the Enforcement Case Information Report, an equivalent of the FIR, is considered an internal document and not given to the accused. Throughout the procedure, the accused does not even know facts of the allegation against him, as the only document which contains the allegation is the ECIR, which is not supplied to the accused persons. Next, contrast to the general criminal law. PMLA is different from the general criminal law. In general criminal law, every accused is innocent until proven guilty. However, in PMLA, this burden has been shifted to the accused person. They will have to prove their innocence. Next, accused found to be a witness. Section 63 of PMLA states that the information must be given by the accused. False information or no information will constitute another offence. Compelling the accused to be a witness against themselves is violative of the right against self-incrimination. Next, inefficiency of ED. The conviction rate of Enforcement Directorate under law is very low despite thousands of cases registered, people arrested, and lives turned upside down. According to the data quoted by the government in the Parliament of India, there were 0 convictions between 2005 and 2013 to 14, and by 2014 to 15 to 2021 to 22, out of the 888 cases under ED, only 23 cases were under conviction. What is the Enforcement Directorate? Directorate of Enforcement is a specialized financial investigation agency under the Department of Revenue, Ministry of Finance. In 1956, an enforcement unit was formed in the Department of Economic Affairs for handling exchange control laws violation under. In 1957, the unit was renamed as Enforcement Directorate. ED enforces the following laws: Foreign Exchange Management Act 1999, FEMA, and the Prevention of Money Laundering Act 2002, PMLA. What is the current stand of Supreme Court regarding the amendments in PMLA? Recently, a 3-judge bench of the Supreme Court has upheld the constitutional validity of the provisions under the PMLA, calling it a unique and special legislation, underlining the powers of the ED to hold inquiries, arrest people, and attach property. SC ruled that no comparison can be made between PMLA and Criminal Procedure Code 1973, including the mechanism regarding prevention, investigation, or trial in connection with the scheduled offence. The SC has also held that the ECIR cannot be equated with FIR. ECIR is an internal document of the ED. Supply of ECIR to the accused is not mandatory, and only disclosure of reasons during arrest is enough, but can merely be informed about the grounds of arrest. International provision regarding organized crimes, as in such cases of money laundering, UN ODC. Criminalization of the laundering of proceeds of crime in Article 6 of the Organized Crime Convention. First, each state party shall adopt, in accordance with fundamental principle of its domestic law, such legislative and other measures as may be necessary to establish as criminal offences when committed intentionally. A1. The conversion or transfer of property, knowing that such property is the proceeds of crime for the purpose of concealing or disguising the illicit origin of the property, or of helping any person who is involved in the commission of the predicate offence to evade the legal consequences of his or her action. 2. The concealment or disguise of the true nature, source, location, disposition, movement, or ownership of or rights with respect to property, knowing that such property is the proceeds of crime, subject to the basic concept of its legal system. 1. The acquisition, possession, or use of property, knowing at the time of receipt that such property is the proceeds of crime. 2. Participation in association with or conspiracy to commit, attempts to commit, and aiding, abetting, facilitating, and counseling the commission of any of the offences established in accordance with this article. How does money laundering affect business? The integrity of the banking and financial service marketplace depends heavily on the perception that it functions within a framework of high legal, professional, and ethical standards. A reputation for integrity is one of the most valuable assets of a financial institution. If funds from criminal activity can be easily processed through a particular institution, either because of its employees or directors that have been bribed, or because of the institution turning a blind eye to criminal nature of such funds, the institution could be drawn into inactive complicity with criminals and become part of the criminal network itself. Evidence of such complicity will have damaging effect on the attitudes of other financial intermediaries and of regulatory authorities as well as ordinary customers. As for the potential negative macroeconomic consequences of unchecked money laundering, one can cite inexplicable changes in money demand, prudential risks to bank soundness, contamination effects of legal financial transactions, and increased volatility of international capital flows and exchange rates due to unanticipated cross-border asset transfers. Also, as it rewards corruption and crime, successful money laundering damages the integrity of the entire society and undermines democracy and the rule of law. Now, we will explore the connection of money laundering with society at large. The possible social and political costs of money laundering, if left unchecked or dealt with ineffectively, are very serious. Organized crime can infiltrate financial institutions, acquire control of large sectors of the economy through investment, or offer bribes to public officials and indeed governments. The economic and political influence of criminal organizations can weaken the social fabric, collective and ethical standards, and ultimately the democratic institutions of the society. In countries transitioning to democratic systems, this criminal influence can undermine the transition. Most fundamentally, money laundering is linked to the underlying criminal activity that generated it. Laundering enables criminal activity to continue. How does fighting money laundering help fight crime? Money laundering is a threat to the good functioning of a financial system. However, it can also be the Achilles heel of criminal activity. In law enforcement investigations into organized criminal activity, it is often the connections made through financial transaction records that allow hidden assets to be located and that establish the identity of the criminals and the criminal organization which are responsible. When criminal funds are derived from robbery, extortion, embezzlement, or a fraud, a money laundering investigation is frequently the only way to locate the stolen funds and restore them to the victims. Most importantly, however, targeting the money laundering aspect of criminal activity and depriving the criminal of his ill-gotten gains means hitting him where he is vulnerable. Without a usable profit, the criminal activity will not continue. A way forward. Firstly, there is a greater need of internal checks and balances. While it is true that law has given stringent powers to the ED in dealing with the accused that can increase the possibility of political misuse, but there is and must be a consensus between the adjudicating authority and the officers of ED to abide by the constitutionality of provision under the PMLA, making the investigation more lucid. Next, the process itself should not become punishment. The ED's expanded powers should not be welcomed with a greater commitment to expeditiously resolve the cases, so both the judiciary and the enforcement agencies can move forward with speedy trials and convictions. Next is operational vigilance. There must be constant scrutiny over the operations of the Enforcement Directorate and the current disposition, whether this clarification will improve the conviction rate, which is right now less than 0.5%. And if there will be any lacunas in the operative part, change is the law of nature. These gaps can be filled either through suitable legislation, executive action, or revised order of the Apex Court. With this, we come to the end of the video. Please don't forget to like the video and subscribe to our channel.